Good morning, Your Honor. I just want to make sure I can be heard. Thank you.
Good morning, Your Honor. It's Chris Winsack. I'm also asking whether I can be heard.
I can hear you.
Thank you.
I just have faith that I'll be heard.
Yes. Do we have everybody here?
Yes, on my end.
All right. Then we'll go ahead and proceed. The only case we have today for oral argument is Nancy Vega versus Grafton Correctional Facility. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. There's two appellants here today. My understanding is that it's been explained to you that you share your time, your total 15 minutes. You can divide that however you'd like. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please keep your voice up. There's obviously no podium today because we are via Zoom. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child if that applies here. We've read your briefs and are ready to proceed when you are.
Okay.
All right.
Thank you. I'm Tom Saxer. I represent the appellant Grafton. Mr. Gray and I will split our time. I'll take roughly 9 minutes, reserving 2 minutes for rebuttal. We were here once before when the court remanded this matter back to the trial court in September of 2024. It did so with a directive that the trial court should analyze the matter under the Waller case. When you review this under the Waller case, granting summary judgment to Ms. Vega was in error. Waller sets forth a two-prong analysis. First, the plaintiff has to eliminate idiopathic causes for her fall, and I'll concede that she did that here. Once the idiopathic causes are eliminated, Waller said that an inference arises that the fall is traceable to some ordinary risk, albeit unidentified, to which the employee was exposed. But the Waller court continued, and there's another part of the holding that I think is equally important. At page 125, the court held the inference is reasonable that the fall was caused by the employment environment once claimant meets the burden of eliminating idiopathic causes, and there was no evidence of any force or condition independent of the employment that caused the fall. When you read Waller, it has to be read in the context of Revised Code 412301 that sets forth a two-pronged standard for a workers' compensation claim in Ohio. The injury has to be incurred in the course of and arising out of the employment, and those are two separate, distinct requirements. In the course of is time, place, circumstance, and I'll concede Ms. Vega was in the course of her employment. The issue we have is whether her injuries arise out of her employment with Grafton. And arising out of requires a causal connection between the employment and the injury. Waller upheld that two-prong analysis. At page 122, Waller held that the conditions of the employment must put the claimant in a position to be injured. And I think more importantly on page 125, talking about that inference, the Waller court held that such a result, the inference that is, does not relieve claimant of their burden of proving a causal connection to the employment. 4 years after Waller was decided, this court, the 9th District, decided Tamarkin versus Wheeler and again confirmed that two-prong analysis. In Tamarkin, this court held that the purpose of the Workers' Compensation Act is not to make the employer an absolute insurer of the employee's safety, but only protect the employee against risks and hazards incident to the performance of the work. Here, there was no risk and there was no hazard. I think the key to Waller is it's premised on an unexplained fall and the inference that arises if there is no evidence of any other force or condition independent of the employment that causes the injury. I think you can look at our case when you apply Waller in two ways. In either scenario, summary judgment's inappropriate. First, Waller's factually distinguishable. We are not dealing with an unexplained fall. Therefore, there is no inference that the fall was caused by an unidentified risk. We know exactly what happened to Ms. Vega on that day. Without getting caught up in the semantics, she caught her toe as she was walking through the reentry room. Her own deposition testimony confirms this. Her deposition is in the record. It's item 26. If you look at page 25, She confirmed she did not trip over furniture or any object. She confirmed there was no substance on the floor, and she confirmed there was no defect in the floor. And unlike Waller, we actually have video of what happened on that day. We can see in real time what happened to Ms. Waller, and lack of a hazard is evident from that video, and that video is in the record item 22. It confirms what she testified to. There was nothing around her when she fell. She was in an open part of the room. It shows her catching her toe and with her momentum stumbling forward. And the fact that another employee just a few minutes earlier was able to walk through that same room in that exact same area and did not encounter any problems is further evidence that there was no hazard present. I think the second way you could look at our case when analyzing it under Waller is that even if you find the fall is still unexplained, summary judgment would be inappropriate. Waller merely creates an inference that the fall is traceable to some unidentified risk, but that inference can be rebutted by evidence of a force or condition independent of the fall or of the employment causing the fall. In the context of Ms. Vega's motion for summary judgment, all inferences have to be drawn in a light most favorable to Grafton. There is evidence, if construed in a light most favorable to Grafton, that would allow a jury to rebut that inference. Plaintiff's own deposition testimony, again, she did not trip over furniture or an object. There was no defect in the floor. There was no substance on the floor. In the video showing nothing around her, she catches her toe and stumbles forward. That evidence, when viewed in a light most favorable to Grafton, I think raises an issue of fact, worst case scenario for Grafton, sufficient to rebut that inference that there was any risk or hazard present that day that caused her fall. I'll concede it was a horrible circumstance, very unfortunate, but it did not arise from any risk or hazard associated with her employment as required by Tamarkin. The mere fact that she is injured at work, absent anything else, does not make this compensable. When you analyze this under Waller, summary judgment in favor of Ms. Vega was inappropriate and it was error. We would ask that you reverse the trial court and either enter judgment in favor of Grafton because there was no risk or hazard associated with her employment, or remand it with instructions that it be tried to a jury if you do believe there's an issue of fact in that regard. Thank you.
Since we're on Zoom, any questions by my colleagues? All right. Hearing none. You're about 5.5 minutes in.
Okay.
Did you want to?
I'll defer to Mr. Gray now, and I'd like to
Thank you.
reserve maybe 2 minutes for rebuttal. Thank
All right.
you.
Thank you.
Thank you, Your Honor. And again, may this please the court. Mr. Saxer was very, I think, detailed and thorough in his presentation, and I do agree with about 90% of what he had to present to this panel. The Bureau's position is simply that this is a case where there are multiple reasonable interpretations of the evidence. There are genuine issues of material fact. And again, as Mr. Saxer had stated, granting summary judgment to Ms. Vega was improper based upon an inference, which the court was required to make in favor of the non-moving party, which includes the Bureau of Workers' Compensation. The Bureau did not file a motion for summary judgment either way in this case. The Bureau presented a memorandum in opposition to both the employer and Ms. Vega's motions. I believe, and the Bureau believes, that this is a case that does need to go before the jury. They are the ultimate trier of fact. They're the ones who will be charged with listening to Ms. Vega's testimony, weighing and evaluating her credibility, watching the video itself to determine, the circumstances that may have contributed to Ms. Vega's fall. So because of all of that, I think summary judgment was inappropriate in this matter. I would also note that in the record, and this was attached to the plaintiff's complaint, we have the copies of the Industrial Commission's hearing orders from 2 separate hearing officers who heard all these arguments and evidence, and they themselves came to 2 separate conclusions. And I think that just goes again to support that this is not a clear-cut case where reasonable minds can come to but one conclusion. We have evidence in the record of 2 conclusions being made by reasonable people. So because of that, I believe this one does need to be remanded. It should go before the jury, and the jury, as the trier of fact, can make the ultimate decision as to the cause of Ms. Vega's fall one way or another. And with that, I would ask for a remand, and then nothing further at this time. You're muted, Your Honor. I'm sorry.
I'm sorry about that. You'll both have 5 minutes left for a full 5 minutes left for rebuttal.
Thank you.
Thank you.
Thank you. You can decide how you want to divide that. And since we're on Zoom, it's time for the appellee's case.
Good morning, Your Honors. Chris Winsack on behalf of Nancy Vega. May it please the court. It's my pleasure to appear before you and to defend what I think was a decision of the trial court that brought light and clarity to this matter in a way that simplifies it in a way that's, I think, very defensible. Initially, we are not talking about something that is paying attention to the law in this whole area. The seminal case in this area, which has done away with the notion of special hazard or risk, et cetera, is Griffin versus Hydromatic, 39 Ohio State 79. Stands for the principle that an injury on the employment premises is by definition unique to its status. And so the existence or absence of a special hazard on the employment premises is wholly irrelevant to the analysis of the on-site injury. Griffin also goes in to start talking about we must be careful not to start using negligence principles in interpreting what's happening here. And that's very much the case here, because Grafton would have us believe that there must be something else other than Miss Vega strictly saying that she caught her foot on the floor to somehow make this compensable. But I think the trial court does a very, very nice job of stating that whether it's gripping her foot on the floor or this is a conclusion, not an explanation on Grafton's part, because it does not appear in the evidence, that she merely tripped over her own feet. That's an observation that is imputed and offered for consideration, but not in evidence, because it was not questioned during the course of deposition. And I think that that would have been highly relevant. Additionally, excuse me, the court makes a very nice distinction saying that there is no distinction here. In other words, that either under the circumstances are unexplained. And for a few examples, if in fact she gripped her foot on the floor or she somehow stumbled, which foot gripped? Left, right? If her feet crossed over each other, was it left versus right? When did she start losing her balance? Was it when her left foot gripped the floor? Was it when her right foot crossed over her left foot? What was it that caused her to, at that point, start stumbling? These are all physical requirements, I suppose, that we are supposed to be held to. And I think that the nature of calling them unexplained is really quite realistic. Just when we were little kids, sometimes our parents would look around and say, what caused you to fall? I don't know what caused me to fall. But they always give us the admonishment, be careful. But they sometimes did not know, but if we were okay, we're okay. In this case, Miss Vega was not okay. Now, the other consideration is that there is no deep dive into what was going on with the floor. There's no mention whether it was recently buffed. There's no mention that it was not buffed. There's no mention that somebody went out and investigated and said, aha, there is something very slippery on this floor. But it went unnoticed. Certainly the injured worker could not do that because she was just about to be transported to a hospital to have surgery next day for a complex fracture. So these are all things that have to be considered and mixed when we talk about something being unexplained. As far as the inference is concerned, Walter stands for the principle that an inference arises that the fall was traceable to some ordinary risk, albeit unidentified, to which the employee was exposed on the employment premises. Such a result does not relieve claimants of their burden of proving causal connection to employment. However, the inference is reasonable that the fall was caused by the employment environment once the claimant meets his burden of eliminating idiopathic causes, and there is no evidence that there is any other force or condition independent of the employment cause that caused the fall. No independent force or condition has been identified by the defendants, in this case, which would somehow create an inference to be unreasonable. And it's an interesting argument the Bureau has that, 56 says that all facts must be alleged or must be evaluated in light of the non-moving, light most favorable to the non-moving party. Excuse me, I meant to butcher that. But at the same time, the Waller case instructs the court as to what is a reasonable inference. And absent somehow challenging that idiopathic causes exist, or demonstrating a force or a condition is independent of the cause of all, then there's really nothing else to do as a matter of law but to call it reasonable. It's up to the defendants to offer facts which would somehow rebut whether this is idiopathic, is in fact idiopathic, whether there are other forces or conditions that are operating. And even before we get to this point in Grafton's case, it is our contention that the law of the case is Waller versus Mayfield, because these facts have been presented to the trial court before. And when this court was instructing us as to what the correct law was, if I may read from paragraph 10, it says, Grafton acknowledges that the special hazard rule applies only to accidents occur off the employer's premises, but based on older cases, suggests that a hazard or risk associated with her employment is still required to demonstrate that Ms. Vega's injuries arose out of her employment. The analysis has been rejected, however, citing the Grimes case, Grimes versus Mayfield, and Waller versus Mayfield. So these are important distinctions. So when this court is advising us that Waller applies, it's not rejecting the trial court's decision necessarily. It is, in other words, apply the wrong standard, but it's rejecting Grafton's arguments. And here Grafton is attempting to re-raise them, having failed to appeal this matter to the Supreme Court, which I think would have been their remedy to take it up. I believe that this is the law of the case that we're bound by it. So when, in its brief, Grafton says that Waller does not apply, even the trial court comments that that's a rather novel posture, indicating that this court has instructed us to apply Waller. And if I may, yes, in other words, Grafton also contends in its second assignment of error that the court finding that Ms. Vega's injury arose out of her employment was an error because it did not apply the correct law, because Waller does not apply. And since I was not ruled against per se, it was rather because the wrong law was applied. I would ask the court to find that Ms. Vega's injuries did not arise out of employment, that I can re-raise these arguments. It's a disingenuous argument because, in fact, the arguments were rejected the first time without reaching whether or not Ms. Vega's injuries arose or did not arise out of employment, because that was yet to be determined by the trial court by applying the Waller standard. So it is the court that says that it is a distinction without a difference, whether she tripped over her own feet, which is not an explanation or an unexplained issue. It is a conclusion, and also that her foot caught the floor is also what was happening that resulted in the fall against the wall. Really, the dynamic is unexplained, other than the simple that the microbe is on. So as far as the Bureau is concerned, that same argument with respect to reasonable inference, I do not think that this motion matter should be remanded for a trial, because these are not genuine issues of material fact. These are matters that can be resolved within the briefing and the evidence that is on hand, that the descriptions of injury that might be in dispute are both on another nature. very unexplained. And I think the court walked through that very carefully. And so that's our position.
Do the other judges have any questions? No? All right.
Oh,
Your Honor, you're muted again. I'm sorry.
The appellants have a full 5 minutes for rebuttal.
Thank you. To address some of the issues Mr. Rinsick raised, I don't think Griffin applies here. The only thing Griffin did when you read about it is eliminated the special hazard rule that was defined in Littlefield. Special hazard was defined as a hazard unique to the employment situs. Griffin didn't eliminate the need for a hazard, it just eliminated a need for a special hazard. You still need a hazard under the second prong of 412301C for it to arise out of, as the Tamarkin case indicated. And again, we don't have a hazard or a risk here. Mr. Rinsick also said that we've made the unsupported conclusion that she tripped over her own feet. Unlike most cases, we have actual video. We know exactly what happened. You can watch the video. She's not near the tables or chairs. She testified she's not near the tables or chairs. She's in an open area where somebody just walked through 2 minutes earlier on the video. And again, I don't want to get caught up in semantics, but she catches her toe and she stumbles forward. Arguing that the floor may have been buffed, there's no evidence of that. They didn't present evidence of the floor being buffed. If she had slipped, her foot would have gone out from under her and she would have fallen backwards, which the video clearly shows she didn't do. She caught her toe, her momentum carried her forward, and she stumbled and fell. So it's not a unsupported conclusion that she caught her feet. The video clearly shows that. I think 412301C, the two elements often get blurred, but they are separate and distinct. Arising out of and in the course of are two separate distinct elements. Waller held they were two distinct elements, and this court in Tamarkin held they were two separate and distinct elements. We don't have a hazard or a risk as Tamarkin required. We have a room that she didn't trip over the furniture, has no defect in the floor, and has no substance on the floor. And that is clear not only from her testimony, but also from the video. It's unfortunate that she fell, but her fall was not caused by anything associated with her employment. And as a result, it does not result in a compensable injury. I would ask that you reverse the decision and enter judgment in favor of Grafton. I could understand reversing and remanding for a jury trial if there is an issue of fact in the court's opinion, but affirming really is not an option from Grafton's perspective. If you affirm, from my perspective, you're really eliminating the second prong of 412301C, and you're essentially eliminating the arising out of requirement for a compensable workers' compensation claim, because here the only thing affiliated with Grafton was she was at Grafton on the clock doing a function of her job, and that is the definition of in the course of. We don't have any evidence that would support the second element arising out of, and for that reason we would ask that you reverse the trial court. Thank you.
There's a couple minutes left. Anything else?
Yes, Your Honor, if I may just very briefly. I would note, again, the Bureau is a completely non-moving party in this exercise. Mr. Winseck had mentioned, well, the Bureau should have to prove something else. It's not the Bureau's burden to prove anything. We're not here to prove the cause of the fall one way or the other. The Bureau's position is there are multiple conclusions which may be reasonably drawn from the evidence before the courts. We have Ms. Vega's testimony at deposition that her foot, quote unquote, gripped the floor. Well, if her foot or shoe gripped the floor because she stepped on some gum outside and dragged it in, that's not work related. We have the video evidence, as Mr. Saxer summarized. You can see Ms. Vega walking through a room. There's no evidence of losing her balance or slipping on anything. Her momentum carries her very strongly, very far forward into a far wall, and she falls forward. So that, again, supports the employer's contention that the cause of the fall is explained. She may have simply stumbled over her own 2 feet. So again, I think there are multiple reasonable inferences that can be drawn. I think there are multiple genuine issues of material fact. And because of that, summary judgment is wholly inappropriate. I would also note here, just for the sake of the record, the Bureau of Workers' Compensation in this claim is very close to being a neutral party from an economic perspective. The employer of record is the state prison system. And what if this claim is allowed and benefits are paid, the prison system has to reimburse the Bureau every cent the Bureau pays out. So we don't have a financial stake in the interest of this case, but we do have a stake in making sure that the legal analysis and the conclusions drawn were done correctly. And it's the Bureau's position that the trial court erred in granting summary judgment when there are multiple interpretations and conclusions that can be drawn based upon all the evidence that was before it. And for that reason, we'd ask for a remand with further instruction to have a jury trial on the matter. Thank you.
All right, any questions from the other judges? Thank you all for your presentations today. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also our opinions are posted on the Ohio Supreme Court website. This court is now adjourned. Thank you.
Thank you.
Thank you.
Thank you, Your Honors.
Have a good day. Thank you.
Thank you.